No interest, no we're sorry, no little extra bump. In fact, the exact opposite. And that's the other part of in Title 16 notice of awards to look out for is deductions. And this is a really tricky area because what are some of the most common deductions that you see being done to our clients?
I would say the most common deduction is
Good afternoon, Hailey. How are you?
I'm great. How are you, Pete?
Good. Well, thanks for joining me today. I really wanted to have this conversation with you, and I think it's been a while. We were on our last podcast, we talked about sort of one of your job duties at the time was to do financial reviews for clients. And as a service to our clients, when they win their case, we receive a notice of award. And when we receive a notice of award, part of your job duty and now kind of your team's job duties is to review those to make sure our clients are getting the maximum amount of benefits that they're entitled to. And I think at the time, if I remember correctly, and I'd have to go back and listen to the podcast, I asked you, how often are you finding mistakes that are done by the Social Security Administration within the notice of award? And do you remember what you said? Was it least?
Yeah, I believe it's rare. Those notices of award are produced by a computer system, so it's rare that the computer is wrong. But every once in a while, it's about 5 to 10% of the time.
Right. Yeah, I think if I remember correctly, I think you said about 10% of the time. So, which is still, though, at volume with the amount of people that win these Social Security cases in a year, that's quite a few people that they can make a pretty major mistake on. So, but before we get ahead of ourselves a little bit, deep dive into the notice of awards, which is what I'd like to do today, is I want to kind of talk to you. There's basically 5 different types of Social Security disability cases, but those fall into 2 kind of legal brackets. You know, as you know, one is Title II and the other is Title 16. And with Title II cases, we look at, that's the entitlement programs where people paid into Social Security, like an insurance program, disability insurance benefits or disabled widows benefits, or adult child benefits. And then there's the Title 16 program, which is kind of a financial need-based program like SSI or children's cases, which not only do you have to prove you're disabled, but you have to prove you're in financial need. And my understanding is that those 2 notice of awards are vastly different. Is that correct?
Yes, they don't even look the same.
Okay. Right.
Like they're produced by 2 different computers.
And 2 different people, like 2 different systems.
Mm-hmm.
So why don't we tackle Title II first and give those folks, and again, Title II is disability insurance benefits or SSDI or DIB, disabled widows benefits, and then adult child benefits. And I don't want to deep dive into the requirements for each individual program as far as disability, but generally, if I applied for a Title II program and I win, either an application, reconsideration, hearing, or maybe even the appeals council, what should I be on the lookout for after just a win?
Right. Yeah. So when you receive your notice of award, it'll be very clear. Up at the top left corner of the first page, it says notice of award in big bold letters. And then right below that, where it kind of goes into the introduction of your award, it mentions when you were found disabled. Sometimes Social Security will change that date, or they will find that you became disabled on a separate date. That information is usually in that first paragraph on page 1. Sometimes it is found on page 2. So I would look out for that. If Social Security does change your onset date of disability, or they disagree with the date that you said you became disabled and found a different date, you are able to appeal that. You would definitely want to review that with your attorney's office to make sure that that would be beneficial for you. But I would look out for that first. And then below that, it would have an outline of your monthly benefit through your back pay. So let's say, for example, I applied and said that I became disabled in 2020. And if Social Security agreed with that date, that my back pay, theoretically, for this example, would go back to 2020. They would have a breakdown of monthly payments from 2020 till present day. And those will change every year through the cost of living adjustment. So you'll see a breakdown for a group of months and maybe the whole year. And then that will increase as the years go on. And then below that, it would... Yeah.
Pause you for just a second there and ask you this. So first, it's not, they don't just say, hey, you're disabled since 2020. They actually give a specific date. Right? Like January 15th of 2020.
Mm-hmm.
So, and then what you're saying is, and correct me if I'm wrong, let's say hypothetically someone's entitled to $1,500 a month in 2020. And then they'll say, okay, for 2020, you get $1,500 a month from, let's say, February 1st, and then they'll say February through, whatever the COLA adjustment was, let's say, February, March, April, May, June, July, right, of 20, and I don't know it off the top of my head, so I'm kind of making this up on when the COLA adjustment happened. But let's say through October of 2020, February through October, and then on the next line, it'll say on November, due to COLA, you're getting $1,700 a month now, or $1,685 instead of $1,500 in 2020 through the end of 2021. And then maybe there was another COLA, so now you get $1,750 a month from the end of 2021 through to the current. Mm-hmm. So what you're saying is that even though the client gets that notice of award, and let's hypothetically say they get it today, and today they say, like, hey, I logged online and Social Security told me I'm going to get, $1,800 a month. If I was to win disability today, I would get $1,800 a month. They're not giving me that higher rate dated back to those 2-3 years ago.
No, unfortunately not. Yeah, it all has to do with the cost of living adjustment. And then so every year, continuing, as long as that Social Security still finds you're disabled, your benefit amount will go up with the cost of living adjustment.
And on a side note, these cases can take, even when you apply, it's about 6-7 months before you even hear back. Do I get interest for the months they should have paid me, even though they denied me?
No, you don't get interest either.
Right. So they just give me exactly what I would have gotten had they paid me in the first place for all the months that I would have been found disabled. So there's no interest. And some of these cases on average take 2 to 3 years where they've denied me the whole time. And then a judge declares them disabled. You're saying they don't get interest on all of that, even though?
Unfortunately not. No.
All right. So walk me through the notice of award. You say sometimes they'll just change the date. Like, hey, I became disabled January 15th of 2020. And they'll bury in on, is it page 1, 2, 3? Do you even know?
Yeah, it's usually in the first paragraph on the first page. It says, we found you became disabled on January 15th, 2023. This date is different than the day that you said you became disabled. It'll say that very clearly. If it's not right there on page 1, it's usually found on page 2.
Gotcha. So something to keep an eye on. What date did Social Security find you disabled? And what does Social Security call that?
When you say you became disabled, that's called your alleged onset date. If it's a different date, or even if it's the same date and Social Security determines that they agree with it, that's called your established onset date.
Right. So your established onset date. So they use a different terminology even for onset date. What else are you looking in the notice of award for?
Below the breakdown, the monthly breakdown for back pay is information about Medicare. It'll tell you when you're eligible for Medicare Part A, Part B. It'll go into detail about that if you're interested about that. And then below that is where it'll tell you about the attorney fees, and it'll also list the total amount of past due benefits or back pay that's owed to you, which is different in the SSI and the Title II notices of award, but it'll say we either approve or disapprove the fee agreement, and then it will list the total past due benefits is this amount. So I'll use that number to confirm that the math that I did through the breakdown is the same as what Social Security is saying in that section.
Right.
And that will also list the attorney fee.
Right. So sometimes what I historically I've gotten questions, and this is a really popular question from clients, because the max attorney fee is $7,200, but 25% or $7,200, whatever's less, right? And so sometimes in the notice of award, in fact, often, if let's say the total back pay is $100,000, okay, let's say this person was entitled to $100,000 in back pay, the paragraph will say, we withheld $25,000 for your lawyer. And you know how many calls I've gotten about that particular paragraph saying, oh, I thought you said it was only capped at $7,200, but now it looks like you're getting $25,000, right? What say you to those clients, Hailey?
It does depend on the circumstance. So technically, Social Security does have the power to withhold a true 25%. If, let's say, you had multiple attorneys that did work on your case, say you hired Evans Disability, but you may have also hired an attorney before us. In a circumstance like that, Social Security does have the power to withhold a true 25% in order to pay out the attorneys for the work that they did on the case. However, we at Evans Disability stand true to the agreement that you signed with us. And if we agreed to a maximum of $7,200, then that is the maximum that we would charge. Even if Social Security were to pay us more, let's say they did authorize us $25,000, we wouldn't accept that because we agreed with you that we would charge $7,200 as the max.
Right. So for administrative law, the Social Security cases, the max we do is $7,200 for our firm to be paid out. And sometimes they do withhold that true 25%, but often it's because Social Security hasn't taken the time to investigate, one, are there other lawyers involved? Was this a federal court case, which also changes the fee agreement? Was this a remand of some sort or an immediate pay of benefits up at the federal court level? So they'll investigate those things. And then usually, often they'll release those funds directly to the client once they figure all that out. So I always tell people, look, I'm not getting paid 72, or and that's hypothetical. I wouldn't have been paid $25,000. They're holding it to sort of look into making sure, like you said, all the lawyers have been paid, or was this a federal court case? Because that does change the fees. Is there anything else you're looking for in a notice of award for a Title II case?
In certain circumstances, there are they'll list eligible children under someone who's eligible for Title II. So those children can also get benefits. That's unfortunately not something that we help with. It's just a simple call to Social Security for the client to complete an application for the children. They don't have to, go through the whole process. It's just as simple as completing an application. We also look for any kind of overpayment that may be in there, things of that nature, just making sure that there's no hold on the fees or if there's any discrepancies with the total amount that I've calculated and the total amount that Social Security calculated in that paragraph that includes the attorney fees.
Right. What is the maximum back pay kind of allowed in a Title II claim?
Maximum total?
In a sense, how far back? Because sometimes people and I know you know the answer to this, and I'm phrasing the question poorly. think sometimes people will say, because we talk about AOD, the alleged onset date. And, today's date is November 27th, 2023. So I'm sure as we speak, there's someone in our firm helping someone apply. Okay. And they'll say, hey, look, I became disabled. It's November 27th, 23. I've been disabled since 2015. Okay. I haven't worked and I don't want to get into date last insured stuff, but let's say, I haven't worked since January 1st of 2015. And so our person will kind of talk to them about that and be like, okay, let's write that date down as your alleged onset date. And when they win, let's say they win their case 4 to 5 months from now, and Social Security says your established onset date is January 1st, 2015. So then they're like, yes, I'm going to get all of 2015, 16, 17, 18, 19, 20, 21, 22, and 23. I have 9 years of back pay owed to me. What say you, Hailey, to those clients?
I wish that were the case. Unfortunately, it's not. So under Social Security law, they are only able to pay you back 1 year before the month in which you applied. So let's say you applied today, November 27th, 2023. If you were found disabled January 1st, 2015, the farthest back you would be paid is November of 2022.
Right. So it's 12. Yeah. So basically how I kind of tell clients, the furthest they're going to go back is a year prior to your filing date. And then you got to take into consideration on Title II cases, especially or in SSDI cases, there's that 5-month waiting period. You have to be disabled for 5 months. So, a lot of times if people are going back 2, 3, 4 years, we're sort of like, look, the furthest they're going to pay you back is that full year prior to your filing date. But we also have to explain to people who who might not go back like to 2015, but they're thinking, I'm going to go back 6 months from now.
Mm-hmm.
Back, let's say to, May of 2023. And they think, oh, well, I'm going to get June, July, August, September, October, November, 6 months of back pay. What say you, Hailey, in that? If it's May 1st of 2023 and it's now November 27th, what sort of expectation of back pay on a Title II case with that person would you tell them to expect?
Right. So there is a law under Social Security that you have to be disabled for a period of 5 full months before you're entitled to benefits. So let's say we were going back to May. They were found disabled in May of this year. Let's say May 1st. So because it's May 1st, that month counts in the 5-month waiting period. If it was May 2nd, that month doesn't count. Anything past the 1st of the month doesn't count as a full month. So it would be May, June, July, August, and September would be the 5-month waiting period. So your back pay wouldn't start until October
of 20. So
this year, yeah.
Yeah. So then they only get 1 month of back pay because November's not even over yet. So, it would be 1 month of back pay.
Mm-hmm.
And I think a lot of times people and you field a lot more phone calls with folks about this than I do these days, but I remember that being a really big sticking point with clients. Like, what? Why? And there's the last I heard, there was a bill in Congress to try to get rid of this 5-month waiting period for Title II folks. And so, or at least something in front of Social Security and the president to try to waive the 5-month waiting period. I think it's silly. But it's there. Is there anything else regarding a Title II notice of award that we look out for, or that your team looks out for?
Not that I can think of off the top of my head.
I mean, yeah, you've walked through it pretty well. The only other thing I would add in, and it's not just exclusive to Title II, it's also, something to think about in Title 16 cases, is that the appeal rights. Because like you said, how often, what percentage of the time, and I know you're guessing, so just no one's going to hold you to this. At least I'm not. Anyone listening, don't hold us to this. With our clients within our firm, especially at the app and recon level, what percentage of the time are you seeing Social Security give a different onset date than the client initially requested?
That is definitely rare. I would say less than 5% of the time.
Right.
And then they didn't change it. It's just a date that the client didn't give.
Right. So they're either denying you, they're giving you the date you want, or they did change it, and that doesn't happen super often.
No, it doesn't. But it does happen. And yeah, as I mentioned earlier, those letters do have appeal rights if you want to argue that.
We have a process actually within our firm. It happens often enough where we discuss it, and I think it's worth mentioning. And what happens is that Social Security is basically saying, we found you disabled, but just not the date you set, right? We don't believe the medical evidence and the law supports disability prior to the established onset date. And we talk to clients about that and say, look, you have these rights to appeal. And you can, especially at application and reconsideration level and the hearing level, you have the right to disagree. At the hearing level, you might see something that says partially favorable at the top. But what we tell folks, and we send this out in writing and in a letter, and then they have a conversation with either one of our non-attorney reps or our lawyers, to talk about what the risks are in appealing a partially favorable decision. So one of the risks that can happen is that if you appeal the partially favorable decision, not only one thing that can happen is they can say, you're right, whoever analyzed this gave you a bad date, let's pay you further back in time. Let's get a new onset date and give you that extra, 6 months to a year. The other thing they can do is say, oh my gosh, whoever made this decision and found you disabled in the first place was out of their mind. You should not have been found disabled. We're going to take you off of disability, and you owe us an overpayment for all the money you collected during that time. Now, that happens very rare, but it also can happen, right? Especially at the hearing level, they can say, we vacate the decision. Now you have to go back to court just to fight back to get what you want. And so there are risks in that, and that should be, kind of thought through. And one of the evaluations we go through with clients is, how much money are you giving up, right? Like, really, how much money if you don't appeal, are you giving up? So if it's like 3 months of back benefits, and let's say the person is entitled to $2,000 a month, that's, they're giving up $6,000. But what I always say, it's not truly a $6,000 because you're still going to have to pay us 25%.
Right.
And so it's 6,000 minus 25% of 6,000, which comes in right, a little over 4,000. So that's what you're giving up. Is it worth the fight? And only the client can make that decision. Right? That's one of the things we look at. The second thing, of course, is the medical records. Do you have medical records that support going back further in time? Or the third thing is, especially if they're in their 50s, and you always can tell, like, we found you disabled on the day before your 50th birthday, because the law changes to make it a little bit easier for a person to win at 50, 55, and 60. So it is quite a lot goes into analyzing, should you appeal these, established onset date that you disagree with, or a partially favorable decision. And in our firm, that's a conversation they have with a lawyer. And if they do go ahead and appeal, we make sure that we send everything in writing. Like, hey, look, you were explaining the risks because, in my 23, 24 years of doing this, I have seen judges take away benefits and issue overpayments to clients that were initially found disabled. So it is harsh. Let's talk about Title 16. What are you looking out for in the mail? So we're talking about SSI and child's cases. What comes in the mail? What does it look like? How do I know it's Title 16 versus Title II?
Right. Yeah. So the Title 16 or the Supplemental Security Income Notice of Award will say Supplemental Security Income at the top, and then right below that it'll say Notice of Award. And as opposed to the Title II, those would say Disability and Survivors Benefits, Retirement, Disability, and Survivors Benefits at the top. So these ones will say Supplemental Security Income. And then the SSI Notices of Award won't actually mention the date that they found you disabled. It's more the day that you are eligible for SSI benefits. So they'll say, we found that you are eligible for these benefits on this date. Therefore, your benefits for this will start on this date. It's not, you became disabled on this date, so that's when your benefits start. For Supplemental Security Income, you are only eligible to receive benefits the month after the month in which the application is filed. So let's say I applied for SSI today and I was awarded down the road. My back payment entitlement wouldn't start until next month. So it doesn't matter if I became disabled in 2015. For SSI, my back pay wouldn't start until next month.
Right. That's a huge distinction between Title II and Title 16. Title II, we talked about 12 months prior, or that 12 full months prior to the filing date. But with Title 16, it's the first full month after the filing date. It's the furthest they'll pay you back. Even if you prove you're disabled all the way back to January of 2015, they're just going to say your first month of entitlement is December 1st of 2023 if you applied today.
Right, exactly.
And what else is in that notice of award? Like, what are the highlighted things that you should look for? I mean, if you're not a client of ours, you should read the whole thing, but we're telling you we're highlights of things to look out for. So a month of first entitlement.
Yeah. And then there will also be that breakdown, like I mentioned on the other notice of award. We'll do a month-to-month breakdown. Those numbers usually or typically will have cents in them, like dollars and cents. In SSI, those cents count. In Title II, they don't. And I'm not sure why they even include the cents. So those will be in there as well. And then there will actually be a total amount listed at the bottom of that breakdown. Whereas previously, when I was talking about the other notice of award, it's on like page 2, the total. It's not listed there for some reason, but for the SSI, it is. And then if it's not the full amount, which for 2023 is $914, if it's anything lower than that, there's likely deductions. And those are all listed on the last couple pages of the notice of award. It'll have a breakdown of the deduction, why it was deducted, and the math they did to come up with the number that you were given for that month.
Right. So let me ask you a few questions. So in 2023, and it's really important to know if you're going to review your own SSI, the maximum amount that you can get is $14 per month. Okay. For 2024, that goes up. It looks like it's going to be $943. Is that what I said? About $943 per month. So, and most people, they applied, that we work with, the majority of the people take 2 to 3 years to get through the program. So just because it's $914 in 2023, it's important to know when evaluating this, just like SSDI or Title II, you only get what you would have received in that year and that month. So in 2022, for example, it was $841 a month. And in 2021, it was $794 a month. And so if you applied, let's say back in 2021, and now you're finally winning your case and you get your notice of award, and it's not $914 all the way back to 2021. It's $794 in 2021 and $841 in 2022 and $914 in 2023. And then if you win next year, it's $943 for those months that you would have received. No interest, no we're sorry, no little extra bump. In fact, the exact opposite. And that's the other part in Title 16 notice of awards to look out for is deductions. And this is a really tricky area because what are some of the most common deductions that you see being done to our clients?
I would say the most common deduction is in-kind support or food and shelter deductions.
And what does that mean to you? And what does that mean that you're kind of seeing?
So typically that means that you are living with someone else, living in someone else's home and not necessarily paying full rent or buying all of your groceries. You're basically getting help from someone else in order to have a roof over your head and, food on your table.
Right.
That's the most common one.
And that's free room and board. Basically, I'm disabled. I was going to be homeless. I had nowhere else to live. So I moved back in with my parents or my brother or my cousin or my sister or someone, and they're not charging me rent. So I get free room and board. And Social Security, so when you first fill out your SSI application or your Title 16 application, one of the questions they ask is, how are you financially surviving? And so you list all that down and they take that into consideration. But circumstances change as well. Sometimes parents can't continue to support their, disabled child or adult child or whoever, or a brother can't continue to financially support their sibling. And so one of the things is that if your circumstances change, just make it official is what, kind of how we talk to our clients. Like if it's really true that you owe rent and your brother or sister or parent is expecting you to pay that rent back and you sign a legitimate lease and you're going to pay it back in a legitimate way and they're tracking it and it's not being relied upon, being paid back is not being relied upon your Social Security check. Social Security will consider that a valid rental contract and likely not deduct your food and shelter deductions. So those are things to look at. And I guess, is there anything else that you look out for in a Title 16 notice award?
It is mostly the deductions. We've seen the most discrepancies in those specific deductions from clients saying like, oh, well, I don't live with someone. I live on my own. Or in these months where I was receiving deductions, I wasn't living with someone. Or there are also deductions for things like child support that one may receive, things like that we would want to talk with the client about and see, are these accurate? Did you receive, additional help during this time? But mostly things like that. It's usually about the deductions that we want to look into that for the client and confirm with them that those deductions are correct.
And you have a right to appeal those deductions as well. So,
right.
And a little less scary to appeal those because really what you're arguing about is like, look, I wasn't receiving rent, and we could take those cases for our clients that we represent, to win the disability part of the SSI part. We will help them fight those deduction cases all the way to court, back to in front of a judge, where that's a singular issue. It's no longer just, are you disabled? It's not about that. We can go to a hearing specifically. We've already established disability. What we disagree with is these offsets. And, look, she was living alone or he was living alone and not living with a parent, as it's suggested here. And unfortunately, with Social Security, sometimes you do have to take it in front of a judge and outline your case that way. Before we completely switch gears here, I wanted to ask you, do you ever see, or does it happen often enough where people will get both a notice of award for Title II and a notice of award for Title 16? And can you tell us maybe how often that happens and why would that happen?
Right. That does happen often. So if you are eligible for Title II, that means that you have the work credits in order to be eligible for that program. You've worked and paid into the system. And then to be eligible for supplemental security income, you as a single person can't have more than $2,000 in assets, resources, or income. For a married couple, it's $3,000. So it is common that people fit both of that criteria. They've worked and paid into the system, but now they're not working and they don't have much money, they don't have any income. So it's definitely possible to be eligible for both programs, and we do see that quite a bit.
Yeah, and I think people should apply for both if they're not sure. You should both apply for Title II and Title 16 if you think you're eligible, especially from the asset requirement in Title 16. And there are occasions where people will get monthly checks from like both programs. And what that looks like is because the monthly amount in 2023 is $914 is the max. But in Title II, they use this acronym called PIA, which stands for
Primary insurance amount.
Primary insurance amount, which is the client's monthly amount that they're entitled to based off of how much they paid in. So we'll use nice round numbers to make our lives easier. So if someone was entitled to $500 through Title II or through their PIA, and they still had less than $2,000 in assets and income as a single person, they could get up to what in SSI?
$414 if they were getting $500 in SSDI.
Right. So then at least they would get the full $914, but the $500 would come from SSDI or Title II and the $414 from SSI.
Mm-hmm.
The one thing I wanted to mention too, just about, because this is another kind of frequently asked question, is when will I get my back check?
Mm-hmm. That is a great question.
And in Title II, and we laugh only because we get this question almost like every day. In Title II cases, when do they get their back check typically?
Right. And I also laugh because it's so unfortunately unpredictable with Social Security when someone will get their back pay, that it's just frustrating to be blunt. But for Title II, it depends on the amount of your back payment. So the larger the amount of your back pay, typically the longer it takes for them to release it.
Right. So what I was told, from management at Social Security is that if it's over $50,000 in back pay to the client, it could take 6 to 12 months before they'll see it.
Yes.
And the reason why is it takes 3 people to sign off on that amount of back pay. Right? So you got your caseworker and the manager or supervisor, and then that person's, supervisor to sign off on this larger amount of back pay. I don't know if that's true, but that's what I've been told. Mm-hmm. Okay. If it's under $50,000 in total back pay, you're likely to get it in 90 days or less after the notice of award and all that. So it does depend on the back pay amount. And we've seen larger amounts actually come sooner as well. So it's not always consistent. And I think it depends on the region of the country. It depends not just the region of the country, but it also depends on your local office, your local Social Security office, or the payment center, depending on who's issuing these notice of awards and how they issue it and all of that. So there's just so many little factors that go into when will I get my money. Mm-hmm. What about SSI? How do they pay that out?
Right. So SSI also, unfortunately, may depend on your local field office, but structurally, your back pay is broken down into installments. So you get 3 installments that come 6 months apart. Depending on your local field office, you may get your first installment, maybe 30 days after your notice of award. Some field offices wait 6 months before you get your first installment. And then it's another 6 months after that, you get your second installment. And then 6 months after that, you receive the remainder of your back pay, whatever is left.
Right. So let's talk about the installments. How much generally are the installments are you seeing in SSI, like the first 2?
Yeah. So generally, the first 2 are around $2,500.
Right. So let's say I'm a SSI recipient. I get $2,500 within the first couple of weeks. I have to wait 6 months. I get another $2,500. But let's say I had a $30,000 back check total that should have came my way. So now I get the remaining $25,000. Of course, we got to take out the attorney's fee. So let's call it the remaining, $20,000. $18,000.
Mhm.
What is there rules around that money?
Yes. So you have a spend down period. Social Security gives you 9 months to spend that money down below the resource asset limit, which, as I mentioned, for a single person is $2,000 and for a married couple is $3,000.
So there's no incentive to save it because Social Security and SSI require that you spend it down. So instead of being responsible, and saving that money for a rainy day, you have to spend it down within 9 months, right? Which drives me crazy, personally. I think it's crazy.
Mm-hmm.
And there are exceptions where you can ask to get your money sooner, and there's a ton of them, and they're listed out within the Social Security rules and regulations, and they're literally listed. You can ask for more of your back pay sooner if you, for example, I think one of them is buying a house. Like if you can prove you're going to buy a house and use this money towards a down payment, because a house that you live in does not count as an asset against that $2,000, $3,000.
Right.
Neither does the first car that you own, but the second car might, or the second car will count against it. And I think they take the lesser value of the two cars to count against that $2,000, $3,000.
Yeah.
So those are kind of the notice of awards, and it's literally math. You go through and you add up, okay, from this month to this month, you were entitled to, X, and here's the sum minus the attorney fee, and this is what you should have gotten, and minus Medicare 2 expenses. Kind of depends on if they decide to go. And I think there's some options like, you can take Medicare back to this far, or, start it here. And the client will have to choose those. And so those are things to look out for in your notice of award. I would recommend that you read it, covered, from the first page to the last page to fully understand your notice of award, especially if you're not represented. And then realize too, if you decide to appeal a partially favorable or, the onset date that's given to you by Social Security, I would highly recommend consulting with your lawyer if they represented you. If it was us, call us. We'll talk to you about it. I'd be happy to. And just to really go through to understand, what am I fighting for? I think that's a really important question I ask all our clients, to make sure, do you know what you're fighting for here? Because it will be a fight and it's a process. And, and we meet folks who say, I just want to be declared disabled, by Social Security, for my back. What if they declare you disabled for your neck or your right arm or your left hand? Is that okay? Or is it just your back? Because a lot of times Social Security says we just find you disabled, and because they're looking at you all encompassed. So that's why if the person really just wants to be declared disabled specifically for their back, it's hard to represent them to meet expectations, because really what we're fighting for is your month-to-month check, your back check, your health insurance, and all the perks that you might get through your state by being declared disabled through Social Security. So, it's not necessarily we can help people prove that they were disabled just for their back, Anyway, is there anything else that we didn't talk about that you think maybe we should kind of throw out there and talk to our folks about?
The other thing that I'll mention is just that for the SSI or the Title II benefits, you'll just get that one notice of award. Whereas for the SSI notice of award, you're going to get so much mail, so many pieces of paper. They'll send one about what your monthly payments are. They'll send one about your back payments. They'll send one about the fee agreement, the attorney fee. So you're awarded supplemental security income. I would expect a lot of mail, especially about the back pay. A lot of people want to know, well, when am I getting my back pay? In the SSI notice of award, it'll say, we will send you another letter about your back pay. Yeah. It all comes in separate letters.
Right. I also would encourage folks, especially if you're not represented and you're listening to this, who are on SSI, if you have a deduction for food and shelter or any type of deduction for any reason, and it's true, right? Like, I was getting free room and board, and so this deduction seems legit. If your circumstance changes, like you move out, you take your, in that hypothetical, I think I said you had a $20,000 back check that you had to spend down in 9 months. And now all of a sudden you're in a land, you move out and you get your own place. Make sure to tell Social Security, run down there to your local office and tell them, hey, look, I moved out. Here's my new lease. Here's my new place. And they can't reduce it for the food and shelter deductions off your current month-to-month check. Social Security will not magically know when your circumstances changes. So you have to inform them. And unfortunately, we get calls from clients that are like, oh, I didn't realize I needed to tell Social Security I wasn't getting this anymore, or I wasn't, getting child support, or I wasn't receiving free room and board. And, and that's a missed opportunity for getting your full check. Mm-hmm. Hailey, thank you so much for sitting with me, walking me and our audience through sort of what to look for in a notice of award, what is a notice of award, and all that good stuff. So I appreciate your time.
Of course, you're very welcome. It was nice to sit with you again.
Thank you.